any settlement in other lands. So clearly policy EN1 is applicable to the proposal. And I've actually set out in full on page 37, because I think this is quite critical, what the criteria are to assess proposals that come forward in those locations. So this proposal, because it involves built development, an element of it is built development, the policy sets out the circumstances in which those sorts of proposals will be considered. Now, the third paragraph on page 37 goes through that. Criterion A talks about proposals in conjunction with agriculture or forestry. Now, clearly this proposal is not for agriculture or forestry, so that's clearly not a relevant consideration. The most relevant one is criterion B, which talks about whether proposals are necessary in the countryside and whether they can be reasonably located within an existing settlement. And I think that's where I want to focus my attention. Now, what the applicant initially submitted was a range of supporting information with their application to seek to demonstrate to officers that the proposals, by virtue of their nature and scale, had to be in a countryside location, i.e. they could not be accommodated within a built-up area within a town or a village. Now, as with all planning applications where the policies of the local plan are particularly relevant, the case officer will consult with the council's community planning team, whose role is to produce and oversee the local plan and lastly the core strategy. So that has been a very clear and important part of the consultation process. Now, the community planning manager looked at the proposals based on the initial submission and was not satisfied that the information provided by the applicant was sufficient to be able to conclude that the proposals were necessary, and therefore on that basis was not in a position to support the application. But in order to come to a definitive view on that, the community planning manager suggested that and requested by the case officer that further information would need to be provided by the applicant in order to try and show how they've gone about the process of selecting this site in order to establish whether or not the proposals could be judged by officers to be necessary in the countryside, and crucially the word reasonably could not reasonably be located within a settlement. Now, again, this has been highlighted by both the applicant and a number of other speakers. There have been a number of alternative sites that the applicant has looked at. We do have some plans that show that, I think. 6 sites were submitted by the applicant in terms of further evidence to demonstrate where they'd looked at within the area. Again, members may be familiar with this, but we're talking here about this is the application site area there, talking about that field. This is also within the EN5 area that are highlighted. This is an area of countryside to the west of the A38, again coming out of Swanwick towards Pentridge. That's a site north of Oakerthorpe, and that site is immediately to the north of Alfreton with the A61 towards Chesterfield there. And there's another, I think there's another plan that shows another site there. Yeah, so that's an additional site. This is Belper here, so this is coming out in a northerly direction from Belper towards Heege. Now those sites, a summary of the consideration of those sites is set out in the report. Pages 41 to 43, if members just want to refer to that. So again, what that sets out is the reasons why the applicant has come to the view that those sites are not suitable. We're satisfied from that information and from their other supporting information that that the applicant has demonstrated that it's reasonable to take the view that this type of facility has to be in a countryside location. And what it says there, the judgment in the policy is not to prove that. It's only to reasonably satisfy us that the nature of the proposals are such that they would have to be in a countryside location. Officers are also aware of a number of proposals for crematoria in other parts of the country and a number of decisions that have taken place on that. And as far as I'm aware, I think the overwhelming majority, if not all of those proposals, have also been in countryside locations or rural areas outside settlement. And I think with that background information, officers are now satisfied that it's reasonable to conclude that it's not practical for a crematorium to be located within a built-up area of settlement. Now, on that basis, officers would take the view that proposals satisfy criterion B of policy EN1, and that is a planning judgment that we've made, and clearly that's something that members will need to exercise their judgment on, whether they feel that the information put forward is sufficient to conclude that it is necessary for this type of facility to be located in a countryside location, and it cannot reasonably be located within a settlement. So that I think is what members have got to look at first. Now, having established that, officers have then turned their attention to policy EN5. Can we just go back to slide 8? Now, as I said earlier, this is a very long-standing policy in Amber Valley, and one that I personally have got a lot of support for. I think it's important that we do maintain an open break between those three communities, and in considering this application we've got to look at the wording of policy EN5, and again I would urge you to look at page 38 of the report. Sorry, 37, apologies, page 37, where policy EN5 is actually quoted there, and it says that the areas of open land between Alfreton, Suncoat and Swanwick will be protected from built development to ensure the maintenance of the settlement separate identity. So again, as that's been highlighted earlier, that is essentially what the policy is designed to achieve, and it's been very successful, I would say, over the years in doing that. There's been a number of development proposals that have come forward, and that area has been protected. But what it does say is the planning permission will not be granted except for development which meets the criteria in policy EN1, or will secure environmental improvements, provide recreational facilities, or improve public access. Now, I'd accept the point that somebody's made earlier. This proposal doesn't particularly do anything in terms of improving public access. It's not opening up land for a public park or anything of that nature. I'll talk a little bit about landscaping earlier on, but the key issue is, does this proposal meet the criteria in policy EN1? Now, having come to the conclusion as officers that the proposals do meet the criteria in policy EN1, in principle, we would also take the view that the policy can satisfy EN5 in terms of the principle of development. Now, I'm going to talk a little bit later about the scale and design and location of the building, which is also important for policy EN5, because just on its own, the principle of development argument, in our view, is not sufficient to conclude that the policy, that the proposal is acceptable in the policy EN5. We also need to look at how big the building is, how it's designed, and where it's located, and I will talk about that a little bit later on. In addition to the development plan, there is the National Planning Policy Framework, and again, members are familiar with the status that document there has in Amber Valley, and given the status of our local plan and when it was prepared, there is a standard form of words that sits at the top of every report now. Members will be familiar with the position that where there is a conflict between our local plan and the National Planning Policy Guidance, the National Planning Policy Guidance will prevail in Amber Valley. And that's set out, as I say, in the standard wording actually at the start of this report. Now, when we look at the National Planning Policy Guidance in relation to this proposal, there's a number of different elements of it that can be seen to be relevant, but in terms of the principle of development, which is what I'm talking about at the moment, I think what we've got to look at is the question of sustainability, and the National Planning Policy Guidance contains a whole raft of guidance on sustainability and sustainable development. But essentially what it does is highlight that sustainable development is about three things. It's about economic issues, it's about environmental considerations, and it's about social matters. So in terms of looking at any proposal, in terms of whether it's sustainable or not, we're looking at what does it do in terms of the economy, what is its impact on the environment, and what does it do in terms of social and community issues. Now, clearly the proposal generates some employment, but I would suggest that employment isn't a particularly significant consideration in relation to this proposal. The employment levels are relatively low, and I don't think that's a particularly strong consideration. From a social point of view, clearly the proposal is providing a facility which the community will be able to use in the sense that they currently have to access other crematorium facilities outside of the borough. So it would provide a facility which will be of benefit to the community. But I would say the critical issue is the environmental considerations in terms of sustainability. And in our view, when we look at the potential environmental impacts of the proposals set against some of the benefits, our conclusion is that there is not a significant environmental impact from this proposal. And I'll talk about how that relates, for example, to highway issues and to pollution control issues and landscape issues a little bit later on. But our conclusion, again, on the principle of development is that we believe, on balance, the development can be seen to be sustainable. So it would, in our view, also be consistent with the national planning policy framework as well as with our own local plan. The number of representations tonight and in writing have talked about need, and I think we need to be very clear as to how the need issue arose. A number of the letters of representation we received did question, and the grounds of objection were that the facility is not needed. Now, again, as a number of speakers have mentioned, there isn't anything in either the national planning policy framework or in our own local plan that requires an applicant to demonstrate that a proposal is needed. So it's not a policy requirement to show whether something's needed or not. And I think one of the speakers raised the issue about competition in terms of whether somebody wants to propose a crematorium. Essentially, it's a commercial decision by an applicant to put forward a proposal. But the need issue nonetheless arose during the consultation, and with officers not being experts on crematorium facilities, we felt that in order to look at that issue and to provide a response to that, we needed to commission somebody who had some expertise in that field. Now, there aren't that many people in the country who have got experience of looking at these facilities and judging as to whether or not there's both a quantitative need and a qualitative need for such a facility. And the company that we selected, we were aware that they'd done other work across the country for other authorities, and we also know that some of those authorities, the work was done for them where we had applications from the current applicant. But I want to be absolutely clear to them that there is no commercial relationship between the applicant and the organisation that we commissioned to do the report. There have been multiple commissions, and you've heard things tonight which have perhaps alluded to the fact that there is something a bit untoward about that. And I want to be absolutely clear, and we've had a written guarantee from the company that we engaged that they have no commercial links with the applicants. Clearly, there is a relationship in the sense that there are other applications in the country from this applicant where this same consultant has been asked by that particular authority to do work on behalf of the authority. But what we've done is nothing different to that. It's true also that we asked the applicant to cover the cost of that independent assessment, and again, members are very familiar with a number of the viability assessments that we've had commissioned in recent months, particularly in relation to the affordable housing issue, where in accordance with our own viability policies, it's the policy of the council to ask the applicant to fund the costs of that third-party assessment. So again, what we've done in this instance is no different to the arrangement we have in place in relation to those matters, and clearly that's enabling us to have an independent assessment as an authority without that cost being at the taxpayer's expense. The reason we set out the brief for Roger Tim, again, people have suggested that it's not a completely thorough assessment of the case for or against need. The purpose of going to Roger Tim and Partners was to look at the arguments that the applicant had put forward, both in qualitative and quantitative terms, and to give us a view about whether those arguments were sound arguments or whether they were not. So that was the particular brief, and that was the purpose for it. And we set out in the report a summary of that study, pages 40 to 41 in the report. The members' reference deals with the need issue, and we highlighted there our view that, having regard to what the budgeting and partners assessment has said, that there is a qualitative and quantitative need. But I would stress that, given what I said about need not having to be proven, I would urge members to concentrate on the policy argument first and foremost, and the needs argument essentially is in response to that being raised as an issue through consultation. If members get to the point where they take a different view on the policy arguments, they may then need to look at the question of need in terms of it being a material consideration. In our view, the need for the proposal is a material consideration, but it is not as significant an argument as the policy argument as to whether the proposal should be supported or not supported. Just talk briefly about highway issues. Page 21 of the report sets out very briefly the summary of the highway engineer's comments from the Derbyshire County Council, and then further on in the report, in the analysis section, we also talk about the highway authority comments. Clearly a number of objections you've heard tonight we've had in writing as well on highway grounds, concerns about overall traffic levels, congestion, noise from traffic, highway safety issues. Those issues have clearly all been looked at by the Highway Authority. The Highway Authority should now look at all planning applications. They've looked at it very carefully and have concluded that they don't feel there's a basis to object to the application, but they have recommended, as is usually the case, a number of conditions which they would wish to see attached to any approval. So on highway grounds, based on the Highway Authority's comments, again our view is the proposal should be supported subject to those conditions. Similarly, in relation to pollution control issues, so we're talking about noise, emissions, any issues of that nature. Quite an extensive section in the report from our own Director of Environmental Services looking at the various issues. So we're actually talking about emissions to air, air quality, noise, land contamination, lighting, as the various sort of elements of matters that could be deemed to be pollution. Now, you'll see in the report, pages 26 through to 29, that it was quite a sort of protracted process here in terms of the relevant officer seeking the necessary information from the applicant and their agent to satisfy themselves as to whether or not the proposal, in their view, could be supported subject to conditions, and there have been attempts to try and clarify and ascertain a number of positions on that, and you'll see that there are three sets of comments in the report from the pollution control officer, which eventually has resulted in a position where they are satisfied that they don't wish to object to the planning application, but there are again a number of conditions which they would want to see attached to any approval, should that be a decision that members take. And they're set out in appendix where we do the conditions. In relation to design and layout, again I referred earlier to policy EN5 and the view of officers that when we're looking at the principle of development, given our views as to how the proposal should be judged against policy EN1 and how that then follows through to EN5. But I'd mentioned at that point that I want to come back and talk about some more detailed issues, because what is different, or I suppose extra, in relation to a proposal within EN5 as opposed to the countryside in general, is how the proposal would or would not compromise the objectives of policy EN5, which, as I said earlier, is to keep that separation between those three communities. Now, can you just refer me to page 13, please? That's it. Now, I referred to this plan very briefly earlier. So this is the entire application site. And the previous plan, which has showed the local plan extract, showed that as a small part of this much wider open area. Now, what we're looking at in terms of development is essentially the crematorium building here, car parking area here, access road into the building there. The remainder of the site being effectively kept in open land use and used for a variety of purposes, which I'll come on to. That building has been designed in terms of its location to be at a point on the site where it is it's least visible from the surrounding area. So if you can just go on to the design of the building. That's an artist's impression of the building as it would look. That would be the western elevation. So as we're looking from, as you go into the site from Derby Road, that's what you would see from that first vantage point. Essentially, I think we can describe that as not too dissimilar to a reasonably large dwelling. It's fairly domestic and simple in scale, sited at a point in the landscape where it is designed to be as invisible as possible from surrounding viewpoints. I'll just go on to the more detail. So again, this is essentially the same view as before. This is the western elevation, is it? That's looking at the building from the eastern elevation. That would be north elevation, the south. This would be the view from Derby Road. These are the proposed entrance gates to the site and a wall either side of there. So by virtue of the scale of the building, the design, which we think is a fairly simple and sort of domestic design, essentially, subject to a condition which requires applicant to submit details of materials, and the location of that building within that particular site, we believe that the objectives of the end would not be compromised. It would still essentially, that much wider area, just go back to 8 minutes. That much wider area there would still perform the role of separating these communities, because we would be talking about a development of a fairly modest scale around that area here. So as a proportion of that wider area,
quiet, please.
We believe that's
we'll listen to you.
Relatively insignificant.
Yes.
I can understand the situation, but just try and keep a lid on it.
In terms of landscape issues, a number of objectors have raised concerns about impact on landscape. There will be some trees are lost initially with the creation of the access point, but there are proposals to reinstate tree planting here. So this is the only part of the site that should be affected by the development in terms of existing landscaping. These are 2 hedges that separate the application site from the north and the south. You've got extensive areas of woodland here, and as you can see, there are proposals to provide additional tree planting within that area. So the impact in terms of landscaping is not something that the landscape manager has got any particular concerns about, obviously subject again to the usual conditions that we would want to see the detailed landscaping scheme, and reserve the right to obviously comment on that as and when it comes in. We'll just look to the photos. Just really to sort of highlight via the photos some of the issues, particularly in relation to the visual impacts and to some extent the landscape as well. This gate here is essentially where the access point would be, and the access is roughly midway along that site frontage to the west, at a point where there's an existing access to the field. So this particular photo there is looking sort of in more or less a sort of southeasterly direction. That's the wood at the top end there. This is coming around a little bit further, looking in a southeasterly direction. This property here is Sleepmore House, which is not actually, as the report says, the nearest property, the second nearest property to the site, about 242 metres, I think, is the figure, away from the building. This photograph here is looking in a sort of northeasterly direction, I think, isn't it?
Mm-hmm.
Thornton's is sort of tucked in behind there. Yeah. And this is, again, looking from the access point in a more sort of northerly direction. These photographs are all of Derby Road, so we're looking here at Derby Road in a sort of northerly direction, and again the access point is just tucked in here. So again, in terms of the highway issues, in terms of visibility, the Highway Authority has satisfied that there's plenty of room for vehicles accessing and entering the site to have sufficient visibility, so there's not a particular issue there. As I say, some of these trees would have to be removed to create the access, but then further planting is proposed to reinstate that. This property here is Lily Cottage. That is actually the nearest property to the site, on the other side of Derby Road. And again, you've got a tree screen there, you've got tree screens here, and again, where the building is proposed to be sited, that should, the crematorium itself should not be visible from that property. Can we just look at the plan that shows, is it number 5, which shows those visibility lines? Right. We had some issues raised by speakers about the Crematorium Act. And again, the council has taken some legal advice on that. It clearly is a material consideration in terms of whether or not the proposals can be in accordance with that legislation. Now, I think what I want to highlight on this plan is the areas of this application site which would, if certain facilities were provided, would not comply with the 1902 Act. This line here is designed to show the 200 yards, which is the closest that any facility can go to a property, from Lily Cottage, which is the property I've just highlighted, which is over here. This line, again, is in relation to Sleepmore House here, which is the second nearest property, again, designed to show how far the crematorium can extend without not complying with the legislation. And this is a 50-yard limit between the building and Derby Road, because there is also a restriction in terms of closeness to highway. So what that effectively leaves is this area in the middle of the site where the crematorium and activities associated with the crematorium can actually take place. Now, have you got the colour version of that? This essentially shows the same layout, but probably illustrates a few points. So you'll see here the crematorium building itself and the various activities that would take place in association with that. Now that would include the chapel, it would include the page 8. So the crematorium building itself comprises a chapel, waiting area, book of remembrance room, interview room, lobby and toilet facility, so that would all be within that complex there. The area to the north and east of the building is the proposed memorial garden, including an area for natural burials. Now what the applicant has had to look at very carefully here, going back to the previous plan which showed those limits in order to comply with the legislation, is to make sure that no activities associated with the crematorium, having regard to the legislation, take place within the site that would fall foul of these restrictions. The 50 yards from the road, or indeed at the other end, public footpath, is also an issue there. And to make sure that those activities are at least 200 yards away from any residential property. And clearly if that wasn't to be the case, and if activities were taking place here that were not associated with that, having regard to the definition, then that would be an issue for the applicant in terms of the legislation.
Mr Stafford, I don't like interrupting you, but I'm going to. I think it would have been helpful if officers have overlaid those measurements on that plan. It would have been clearer for members to see.
And burials.
Yeah. Because from here,